All right, why are you threatening to send out videos?
I made a mistake.
No, you didn't make a mistake. You made a choice.
I made a choice. I made a bad choice. Didn't think why with the action.
Like why? And why were you knocking on her door or knocking on her window? What were you expecting?
Talk about my daughter, but it didn't help at all.
Well, what time did you go to talk about your daughter? What time was it?
Uh, it was late.
What does late mean?
Past bedtime, 10 o'clock, I think. Well,
All right, nobody's knocking on somebody's door at 10 p.m. to talk about their daughter or talk about their child. They're usually there for something else. Did you call her? And I see you called her and she blocked you. I'm sorry, defense counsels, have you received discovery from the state and did you review it with your client?
We
Yes,
have,
ma'am.
Your Honor, and we did.
All right, court will find that the state is in compliance with discovery. Mr. Carter, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsels, do you waive the reading of the indictment?
We do.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with the offense of publishing or threatening to publish intimate visual material as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? All right, why is everybody whispering today? All right, that's okay. It's like people are whispering for some reason. I can't hear. Court reporters having a hard time hearing. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
All right. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Counsels, has your client been able to provide you with any defenses?
Yes, Your Honor.
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Yes, Your Honor.
Mr. Carter, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea?
It is.
State is at the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Just for a moment. Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Outside the
No.
agreement, thank you. Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 100 hours community service restitution, TAP evaluation. The state has put zero tolerance. I don't do zero tolerance. You know, either you violate your probation or you didn't, and then I make decisions on that. A mental health evaluation, parenting classes, anger management class, BIP class, no harmful or injurious contact with the complainant. Did you understand that to be your plea?
Yes, ma'am.
Defense is at the plea. Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Judge.
I'm sorry, not the plea. Did you understand that those recommendations are recommendations from the state and the court does not have to follow those recommendations? And those are the recommendations that the court previously read which is the state is recommending 2 years. So I don't have to give you 2 years. I can give you more than 2 years. 100 hours of community service restitution. I can give you more than that. The mental health evaluation, parenting classes, anger management class, BIP class, and the no harmful or injurious contact. You understand that?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers State Exhibit 1 and attachments.
Without objection.
All right. And
No
state,
objection.
thank you. And state, have you spoken with the complainant?
Yes, Judge, and she's here today.
All right. Mr. Carter, did you review the waiver and stipulations of testimony with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Your Honor, we'll waive PSI.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. So this, the offense as charged, right? Whenever you see that offense on paper, you know, it gives a certain impression. Our client was in the throes of custody issues. He understands that he made the wrong decision to take his anger out in that way, rather than, you know, addressing it in a healthy manner. Mr. Carter volunteers as a football coach at a local high school. He is a former NFL player, and he is giving his talents and giving back to the community in that way. He is fully committed to continuing that path. He is fully committed to working on himself, and this incident does not define him. He is remorseful, and he's ready to change under your supervision.
All right, why is there a request for BIPP? I'm sorry, you're not the attorney on this, but I mean, I understand that this is seen as a form of abuse, but isn't BIPP for physical?
Battery.
Yes, Judge, and I can just imagine, because it's someone who was a spouse of his, and this is not just some random person, and so.
I mean, I'm not going to order that. How old are you?
46.
All right, why are you threatening to send out videos?
I made a mistake.
No, you didn't make a mistake. You made a choice.
I made a choice. I made a bad choice. And didn't think why.
Like why? And why were you knocking on her door or knocking on her window? What were you expecting?
Talk about my daughter, but it didn't help at all.
Well, what time did you go to talk about your daughter? What time was it?
It was late.
What does late mean?
So this time, 10 o'clock, I think. Well,
all right. Nobody's knocking on somebody's door at 10 p.m. to talk about their daughter or talk about their child. They're usually there for something else. Did you call her? And I see you called her and she blocked you.
yes, ma'am.
All right. So it appears that she doesn't want you anymore. I don't know why people can't accept that. And it's not like you're a teenager. Even teenagers, when somebody doesn't want you anymore, you can move on. As my grandmother would say, cry on the inside. Don't let that person know they've broken your heart, and just move on.
Yes, ma'am.
I don't understand why you don't understand that.
If I may, I think context matters here.
Oh,
My understanding is that the complaining witness was withholding visitation from my client, and he had no way to do it. A custody suit has ensued, and they're working that out. But during that time, they were breaking up.
so why would he go over her house after 10? Why not go over there at lunchtime? Why not go over there during, daylight time?
I think he was frantic, Your Honor. And he understands,
No,
right?
I want to find out if he was frantic. He hasn't told me anything.
I just reacted the wrong way.
No, but I mean, why go to her place at 10? And the reason why I'm asking you these questions, it's so I can determine whether or not all of these extra conditions that the state is asking, whether or not that's appropriate.
Because at the time I was allowed to come over there anytime I was so serious, and I thought we could go over there.
What do you mean you were allowed to come over at any time?
No, because I used to go over there like to see my daughter. I leave to go home by 8 before she go put in bed. And all of a sudden, then she got mad at me, and then she blocked me, and I was just talking to her, and I just went over there, and I should have went over there.
Mhm.
That's when the custody thing came up then after the fact.
So what family members do you have in San Antonio?
None. I moved out here just for my daughter.
To co-parents
To Courtroom.
from Alabama.
We was trying to get together. I bought a house here, and we're not together, so I'm stuck in San Antonio. So I said, and I only got here about my daughter here. That's it. I don't have no family.
So how do you all discuss childcare issues? What is happening with that? Is it through the app?
Right now, we've been talking to each other on the phone, and my daughter got a watch, and I've been hanging out with her when she allowed me to see her. Take her to eat. Supposed to be going to see the light show tonight, so I mean, that's what I've been contacting.
With the complainant and the daughter.
Right.
So they're amicable.
Within both of us.
Well, here's the thing. People hang out with each other and then they think things are great. And then maybe they'll decide that they're going to get back together. You shouldn't do that because whatever issues y'all had previously, these same issues are there.
Judge, he also has a daughter that's 17 that is in the state championship as a wrestler in Alabama. She's already not committed, but she's been offered a full ride to the Naval Academy. So we'd ask that he be able to travel freely between Alabama and I guess Annapolis, right? Should that be where she commits?
All right. So what I can tell parties, I don't know why people get in relationships and then they have this issue with the children where people are not letting people see each other, not letting people see their children. But this is what I can tell you. When a relationship is over, it's over. Don't try to get back in that relationship. You and the complainant are supposed to be adults and everybody's supposed to be putting their children first.
Yes, ma'am.
And when people hurt the mother of their child, the father of their child, just being petty, then you're hurting the child. Do you understand?
Yes, ma'am. I understand.
And I can tell you, until things were explained to me, I was close to giving you jail time as a condition. But now I'm able to see everything and the state was not asking for jail time as a condition.
Judge, again, context, complaining witness and my client went to the same school, Troy University, in Alabama. And he played football for the school and she was an athletic trainer, correct?
Yeah, I've been on a lot.
So it's been on and off relationship for 20 some odd years. Is that right? 6 years.
It's been a while.
Then the baby came along and tried to do the right thing, moved to Texas to co-parent, and things happen.
All righty. This is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. The coaching that you do, are you paid for that?
No, ma'am.
Okay.
I'm
So,
gonna get paid for it.
all right. So there's to be no there's to be no employment as a home health care provider or with minors. There's to be 100 hours community service restitution. Ms. Abrams, if you verify that he's actually coaching, that can count towards his community service hours. Field visits 1 time per month for 3 months. And the complainant is requesting the no harmful or injurious contact.
Yes, Judge, and the idea is for the child custody and transferring.
All right. And there's, yes.
He has total and permanent disability with the NFL. And so he's not allowed to work for that
He'll need to provide proof of that.
Okay.
All right, so proof of employment within 40 days or proof of inability to work. And the court will require an anger management class. And I'll require a parenting class. Probation, is there anything else?
With no harm for injuries contact.
Oh, I'm sorry, I wrote it in, but I didn't say it. No harm for injurious contact with the complainant. All right. Is there anything else that you need from the court to be successful? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. If you complete everything early, the court will consider early termination.
And Judge, I may have not on it, but did you allow travel?
Ms. Abrams,
Yes.
he's allowed to travel to
Alabama.
events with his other daughter. So he's allowed to travel to out of state. Because maybe they're going to go to another wrestling tournament other than Alabama.
And is that just particularly to his daughter, Your Honor, or can it be
Yes.
also, he has an elderly mother because that lives in Alabama, he helps care for, he's the only child that can care for her.
All right, you all will just need to approach on that. Your attorneys will need to turn that over to probation.
Thank you.
Okay.
Thank you.
4. All right, Vashawn, just go ahead and say he's allowed to travel out of state for his child and also for his mother, and there's to be UA upon return. So that'll be a UA within 24 hours. So if you leave and you come back, it'll be the UA the next business day. And you can either do UAs or either you can do the patch. The patch costs more, but with the patch, probation will just put a patch on you. You don't take it off, don't tamper with it, because that'll be a violation of your probation. They will pull it off and then they'll test it. All right. Did you review the trial court did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. We're off the record. They're saying they have a victim impact. Basically, what ends up happening is the complainant speaks to you.
Judge Boyd's courtroom, former NFL player Kevin Jones isn't here for a highlight reel. He's here because he weaponized his ex's privacy. After late-night pounding on her door around 10 p.m., blocked calls, and a furious custody battle, he crossed the line by threatening to blast her intimate photos and videos to the world. Today, that rage-fueled choice turns into a felony reality. The judge tears apart his excuses, puts him on 2 years of strict deferred probation, orders anger management and parenting classes, bans any harmful contact, and warns him that one wrong move could turn those deferred years into real prison time.
6129, State versus Amanda Lynn Farias. Could I have parties announced?
Rick Pena for the state of Texas.
Joseph States who for Monica Guerrero.
And are you Miss Farias? All right. Counsel, do you want to place on the record your representation of her?
It's a retained case. Monica is retained on this one. I work for Monica Guerrero. Miss Farias, do I have permission to do this in front of Judge Boyd today?
Yes.
All right. Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Farias, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, State will be proceeding on count 1, paragraph B. We will waive paragraph A.
Any
No.
objection?
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with burglary of a habitation. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Oh, no contest.
You don't want to go to a jury trial.
No.
You work a deal out with the state. You want the judge to follow the deal.
Correct.
All right, so I want you to hear what I'm saying and internalize what I'm saying.
Okay.
You have a right to a jury trial. Do you understand?
Yes.
Do you want a jury trial? You want to enter this plea?
And then plea.
All right, you have a right for your attorney to cross-examine witnesses that the state calls, or you can cross-examine them yourself. Do you want to do that, or you want to enter into a plea?
And then to plea.
You have a right to remain silent. Do you want to remain silent? Do you want to give up that right, or do you want to enter into this plea?
And then to plea.
All right. Court will find that, just 1 second. All right. Did you understand, if I grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Farias, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
And
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. There's to be no contact with Oscar Castro, Yemi, Vanessa Bayo, Mandragon, Jesus Leyva, and the address of. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 7 years. There'll be 200 hours of community service restitution, the BIP course, TAP evaluation, follow our recommendations, and MRT. Is there a affirmative finding that's being requested in this case?
Per the code, this charge doesn't come with an affirmative finding, Your Honor.
All right.
It's for Title V offenses only, and burglary of habitation does not.
All right.
under
Well,
Title
I'll
V.
read the facts and we will see.
Yes, Your Honor.
All right. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged in paragraph B, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. At this time, state offers into evidence its Exhibit 1 with all attachments.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Our client's remorseful that this had happened. What's not in your The stipulations, not to your knowledge, is that there was some abuse, possible molestation from the complainant against her child. And that led to this event.
Well, have there been charges filed for that allegation?
Not to my knowledge, Your Honor.
Any evidence presented to anybody for that?
This is the first time I'm hearing about it.
Okay, all right, you may proceed.
The client is employed, self-employed, does meal prep. There's a $1,500 fine. However, she may not have consistent income. I know this is for 7 years. I was hoping that the fine could be probated. She does do not professional home health care, like not a caregiver per se, but she does have to be around other people in a sense of making sure somebody doesn't fall over. If somebody needs something, she may help them. We're under the impression that this was not the affirmative finding of family violence. I had advised her that it likely would be imposed. And I would hope that you would follow the plea bargain agreement as written.
All right, so why were you over at that location? Because it appears from reading the stipulations that you were not invited.
Correct. Well, I was informed that he was there by him. This was ongoing abuse that I had been through with him. He would stalk me. He, would find where I was. And that night I was with my friends and he was telling me that he was going to come looking for me and that he was going to find me. Anyways, it led on to the next morning. He was still contacting me. He told me he was there. I was telling him to leave me alone. Long story short, we ended up getting into it, over the phone. So I went over there to where he was at. And that's how I ended up there.
I don't understand that. I don't understand why you would go to a location. Your attorney is saying you're in fear of him, but you go to the location. And then did you see the photos?
Yes, ma'am. And he's currently out. He was guilty of putting his hands on my son and myself as well. He's out right now. I think deferred. I don't know. I couldn't tell you the legalities of that, but and that wasn't his only time. After I was arrested with this, he came to my house looking for me again with a gun and put it to my head. And because there was a restraining order, he had one on me. I ended up getting arrested. And so this is, even me on house arrest, he was still messing with me. So I understand that I wasn't supposed to be there or I went looking for it. But I think that just me being, provoked and going through what I was going through with him, I snapped, I guess.
Well, if he's on probation, shouldn't he have a no contact order as well?
Well, I believe that was all done prior to this taking place. His own separate case that he was placed on deferred was completed prior to this.
So he's completed probation.
He's not completed. He's on deferred at this time.
All right, so there should be a no contact order. Is that out of this court?
I don't believe so. No, it's in a different court.
Oh, okay. Well, I would have ordered a no contact, so
Sure.
maybe somebody should let probation know to reach out so there can be no contact.
That's right.
Do you all have children together?
No, ma'am.
All right, so there's no reason to have any contact with him.
Yes, ma'am.
Court is going to sentence you to 7 years deferred adjudication. There's a $1,500 fine that will be probated. There's to be no contact with Oscar Castro, Yemi, Vanessa. And Ms. Abrams, that's Yemmi, Vanessa, Bello, Mondragon, Mondragon, Jesus Leva, Levya, and The BIPP course, TAP evaluation out of custody, follow recommendations. 200 hours community service restitution. I'm going to order the BIPP course. Once that's completed, 100 hours be deemed satisfied. The MRT course, once that's completed, 100 hours be deemed satisfied. Field visits 1 time per month for 6 months. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. Probation, is there anything else? Is there anything else you need from the court?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue where he's bothering you, you need to let probation know. And maybe you can see if their probation officer can recommend that as a part of his conditions of probation, that he has no contact with you. And then if he were, that would be a violation of his probation. My understanding, his case is not out of this court. Otherwise, he would have had a no contact order. All right, good luck to you.
Judge,
You're welcome.
just one clarification. The meal prep that she does is not significant. She does a side thing of helping others where it's not in a,
I mean, she's just
legal
doing meal prep and dropping it off.
she may assist somebody with in the house movements, not making sure they don't fall over.
In Judge Boyd's courtroom, Amanda Lynn Fias isn't here for some minor mistake. She's pleading no contest to burglary of a home tied to a toxic, violent relationship. After years of stalking, threats, and a gun once pressed to her head, Amanda finally snapped and showed up at his place uninvited. And the photos of what happened inside are brutal. Today, instead of a prison term of up to 20 years, she's walking out on 7 years of strict deferred adjudication, 200 hours of community service, abuse intervention, and a lifetime ban from the people in that house. One more step away from the man who destroyed her life.
And you're Mr. Prince?
Yeah.
All right, Mr. Prince, you entered a plea bargain agreement with the state to count 1. The enhancement was found to be true. My understanding is that the plea bargain agreement, the state is to remain silent on your application, and punishment is to be assessed at a cap of 7 years. And there's to be no contact with UT Health Science Center except for medical treatment. All right, Mr. Prince. It appears you have a problem with stealing. So why, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record. All right, why do you steal? Why are you stealing? Well, I mean, you do know, because it takes some thought to do it. And let me just tell you, the only reason why the state is silent, the only reason why you're going to receive probation for this from this court is because of your medical issues. And I know that the jail and the prison system, they're not 100% equipped to provide you treatment you need for your leukemia. Otherwise, you should be going to prison. And obviously, maybe there's something mentally going on with you. Usually, I know when people are going through treatment, sometimes they need therapists for mental health, because sometimes treatment is a roller coaster. You're doing great, you're not doing great. So I understand that. And your attorney has brought to the state's attention and to the court's attention the fact that it is true that that's your diagnosis, that you have been receiving treatment. And that is why you've been at the Health Science Center. So this is what I'm going to tell you. I'm going to grant your application. However, I will only grant your application if you're applying for deferred adjudication. And I do have your application for deferred adjudication. And I'm going to place you on deferred adjudication. And you know why I'm doing that? Because if for some reason you were revoked, you're subject to the full range of punishment, and that's up to 20 years in the prison. So you had better not steal anymore. You understand? If you want things, you need to work for things, and you can not use the fact that you have medical issues as an excuse to steal. All right, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. Here. The mouse is slow.
One factor and component I think the court needs to be aware of as well, in his medical records, it does indicate that he has been diagnosed with partial idiopathic epilepsy with seizures.
Okay.
So that'd be a physical thing, not a mental issue. However, I'm not sure how that would be addressed other than through medical procedures and medical medication.
Okay. All right. There's going to be 6 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. Are you employed? So how do you support yourself?
Well, I'm getting assistance from my family.
Okay. I cannot hear you. You're going to have to speak up.
Sorry.
That's okay.
I'm getting assistance from my family.
Okay. And do you live with someone or you live by yourself?
By myself.
All right. Do you have any children?
They're grown.
All right. There's going to be proof of employment within 45 days or proof of SSI within 45 days. Or you can provide medical documentation that he's unable to work, and that needs to be done within 45 days. If not, he'll obtain employment, and he's not allowed to have any employment as a home health care provider or with minors. There's a $1,500 fine that will be probated. There's to be no contact with the Health Science Center except for treatment. Restitution, if any, to Melinda Stelp, STELPFLUG. There's going to be 100 hours of community service restitution. I'm going to require the anti-theft course. And Ms. Abrams, when is his MIC evaluation scheduled? All right. And he's to attend the MIC evaluation. If you miss that evaluation, a motion to revoke is going to be filed. You understand? All right. Field visits, 1 time per month for 8 months. Probation, is there anything else?
No, sir.
Do y'all need him to do a medical release?
Judge, his officer will go over that with those guys.
All right, so you'll need to provide any type of medical information. If your doctor says you aren't able to work, you'll need to provide that to probation, and you need to do that within 45 days. Do you understand?
Yes.
All right, is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Work something out for those who can.
Yes.
I will go back on the record. She's going to be reading not true to the violations.
All right. All right, we're back on the record. You may proceed.
Violation of condition number 10 in Bexar County, Texas. Between the date the defendant Rose Padilla was placed on community supervision and the date of filing hereof for restitution, the defendant should have remitted $81,135.98, but has only remitted $2,504 in violation of condition number 10.
How do you plead to that? True or not true?
Not true.
Violation of condition number 21, on or about the 17th day of June 2025 in Bexar County, Texas, the defendant Rose Padilla did then and there call to complete GED as instructed by the court in violation of condition number 21.
How do you plead to that?
Not true.
And violation of condition number 23 in Bexar County, Texas, the defendant Rose Padilla did then and there call to make payments of $100 every 2 weeks in violation of condition number 23.
How do you plead to that? True or not true?
Not true.
All right. Will you all be ready to proceed on a contested hearing the second or third week in January?